I'm thinking of selling my firm after getting some inquiries from potential buyers. What should I expect from a law firm if I hire them for due diligence around the acquisition? Would answering that question help you?
Yeah.
Okay, perfect. So we actually handle M&A transactions. This is known as M&A, mergers and acquisitions. We represent on the sell side and on the buy side. We've got
Hmm.
quite a few in the works right now. For example, we've got a closing expected at the end of this week where our client is buying a business, the actual equity. We've got another client where they are selling their business, the actual equity interest. And we've got another client um, where they are selling their assets. And all of them are in negotiations right now. So some of them with very short timetables on closing, and the others where maybe we're looking at closing in September. And we've represented clients from pre-LOI negotiations when they had a vision for selling their assets or their business and they wanted to get ready in advance of that happening, or be mindful of what they needed in place before that happened. And we've represented businesses after we get a signed LOI, right? And in rare cases, we've agreed to represent a business when we were introduced to it only after they signed the purchase agreement and they were in the midst of due diligence. But that's extremely rare because it's you need a super narrow scope to be able to make that work in a responsible way. So we've got a lot of experience with this. What should you expect when it comes to due diligence if you are selling your business interests, not assets, but business interests, right? Your equity interests, your actual shares
Hmm.
or membership units, depends on the type of business entity you have. You want to look for a law firm. This is what they will do. Number one is they're going to want to be clear with you on the scope. They're going to look at the LOI that you signed if they were not part of negotiating it. And first of all, I tell people get a lawyer involved for negotiating the LOI because once you have that LOI, usually you're sticking very closely to it for the purchase agreement. It's really hard to renegotiate disadvantageous terms if it's already signed up. So at least have someone look at it so that you know what's missing or you know what might need to be changed. I've had people go online, they get one, and I'm going to tell you right now, when we use templates, we use databases, paid databases that we sign up for templates, things like Thomson Reuters, Westlaw, and LexisNexis. They have databases with tens of thousands of forms and very detailed drafting notes and links to court cases interpreting the language and things like that. And so there's almost always different versions of every template. There's, for example, with an LOI, it might be a letter of intent, which you sign before the sale agreement, before signing the sales agreement, and before entering into most of the due diligence. When you sign that LOI, uh, when we go to get an LOI template, there's a buyer version, pro buyer, and pro seller. There's pro buyer assets, pro seller assets, pro buyer equity. You see what I mean? So
Hmm.
I tell people be very cautious what you're getting off of the internet because you don't know the slant. There is no neutral. You don't know what slant that agreement came from or how they adapted it for their unique interests that are never going to be disclosed to you, right? So there might be things that would normally be in there that are taken out, but you don't know the reasons why or if it hurts you that they're taken out, and you don't even know that they're taken out, right?
Hmm.
So what do you expect? What happens after signing the LOI, going through due diligence? Usually there was already at least a little bit of due diligence to get the LOI signed, and
Hmm.
that's mostly going to be around like financial terms, business terms. Once you get the LOI signed, if you're selling the equity interest, there will be a lot of interest in the business formalities. If it's a corporation, they will want clarity. And usually, what the attorneys are doing is spending a lot of time making sure that the corporate particulars are well attended to. And if they were not, you're usually in a position of drafting curative resolutions to make up for what didn't happen but should have happened previously. So that involves reviewing the formation, those initial consents, any resolutions that were done, your activities. There's usually a look back period.
Mm.
So you'll negotiate a look back period. How far back do we have to disclose? And that's how far back they will go. But sometimes they need to go even further if they're trying to trace title to the equity. So that's a huge area of interest for due diligence if you are selling equity interests and it's a corporation. With an LLC, depending upon how formalized you made the LLC, it may involve as much activity. If it's a very streamlined LLC without a lot of formalities, then it may not be as particular, but you still may need some curative resolutions if that was missing. Some other things you would need is there's usually due diligence around intellectual property, but it will be influenced by whether the brand name is a considerable part of what's the purchase price, right? So brand name, domain name, any copyrighted materials, training materials, policies, things like that. If you have a database of materials, they will want to know what sort of protection exists for that. So that's a big part of the due diligence. Even if you don't have registrations, they may want due diligence and conversations with counsel around the likelihood of being able to get protection for those items. They want to
Mm.
know, is the purchase price really supported by the activities? They'll want to know about litigation, actual or threatened. And if you have anyone who's worked in the business, whether as an independent contractor or as an employee, there will probably be intense due diligence around that. Who was in the business? How were they classified? Any potential claims? A lot of times we're doing FOIA requests to see if there were any state level charges that were never flagged, right? Maybe there were inquiries that happened that never rose to the level of um, being note where the business was noticed, or there could even be situations where there's a default judgment, but they never went forward with collecting on it. This happens. So that gives you a sense of what the due diligence looks like. And then a huge part of that are the disclosure schedules um, that go along with the purchase agreement. So it's a lot of activity because you're drafting the purchase agreement, you're negotiating those terms, you're doing the due diligence, and then the main thing is disclosure. If you disclose, usually you're in a really good position.
Mm.
So it's putting everything on the disclosure level schedules. Now, one big thing is that you disclose per what's required.
Mm.
And this is where a lot of people sometimes they over disclose and it's not required. It's not required based off of the terms. So um, it I tell people it's so much easier if you've got legal counsel involved before you sign that LOI because you can get a little bit of the preparatory work done instead of waiting until a crunch period between the LOI signing and the closing. If you've got less than 2 months, it's a lot to get done in that 2 month period between LOI signing and closing.